advised, the Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning, all. I am Judge Faruya. To my right is Judge Morse, and to my left is Judge Weinsweig, and we are here for oral argument in our case number CV23-0725, Patagonia versus ADEQ and South32. As you may know, we record and live stream these proceedings, so please give the name of your client and your name prior to beginning your presentation. You have a maximum of 20 minutes per side, although you are not required to use all of that time. We do require that you keep track of your own time, and the clocks in the podium reflect that time remaining in minutes. Please be aware that it also includes any time that you want to reserve for rebuttal. Keeping track of that will be your responsibility. Please keep in mind that we have read the briefing, studied the record, and discussed this case in conference. And with that, you may proceed.
Thank you and good morning. Nick Ansel and my co-counsel Chanel Reyes here on behalf of Patagonia Area Resource Alliance. Glad to be back at the Court of Appeals. I'm hoping to reserve 3 minutes for rebuttal, so I'll keep my fingers crossed. There are not many laws in Arizona that protect our water, and ARS 49244 is one of them, and it's an important one. And it is one that ADEQ is ignoring. And they're not just ignoring it in this case. As they concede, they are ignoring it in over 200 different permits across Arizona. They're ignoring this because the clear language of 49244 means they must be monitoring, checking the water in the aquifer at the point of compliance, number one.
So let's talk about that. Clear is your adjective, right? And so let's look at the actual words of the statute. It says the point of compliance is defined as, quote, the point at which compliance must be determined. So in your mind, does determined mean the same as measured, means the same as monitored? They're all synonymous?
It means the same because of the context in which it is used. Now,
but without looking at the context, just the plain language, do you have a dictionary definition for me of the word determine?
So I believe opposing counsel briefed on the dictionary definition of determined. And to me, the question facing this court is not what is the broadest conceivable conception of the word determine. I could determine that there won't be traffic coming home without looking at whether there will be traffic on the way home. What is the determination that's required by the context of this particular statute? And that's what people do all the time in basic language, and it's what this court does all the time in terms of statutory interpretation.
I think our goal is to discern and affect the legislature's intent, not to do things broadly or narrowly. So focusing again on that, what we're asked to do is to identify the legislature's intent. And we have a word, and the word is determined. It's not measured. It's not monitored, which is used elsewhere in the statutory scheme, right?
That's correct. Right there, it's not monitored.
So I'm asking you on a plain language, before we resort to tools of secondary construction, what is your authority that determined means measure?
So the authority is Drummond itself. And what Drummond said is context is not just a secondary method of interpretation. It is a primary method of interpretation that you, like with mobile home in the Drummond case, which could mean something more broad, it could mean something more limited. What is exactly a mobile home as intended by the legislature? Look at the statute. Look at how it's referring to the determination. Look at how it's referring to mobile home. So here, the point at which compliance is determined, that means the determination is happening at a physical point, a real point. It's not just using the word determination in the abstract. We can do anything we want to make that determination. It's using it contextually, and that's just that one sentence. If you keep reading the rest of the statute, just as you would in the Drummond cases, our Supreme Court did, it makes absolutely clear, monitoring is mentioned over and over, that you can establish monitoring in another aquifer in lieu of monitoring in the uppermost aquifer.
Let me ask you, are there any other tools in either ADEQ's toolbox or the mining toolbox to determine compliance? Other than digging a well, grabbing a glass of water and testing it. Are there any other possible tools to determine compliance?
I'm not exactly sure. I know the most common method, and I think all parties would agree, would be the use of a monitoring well at the point of compliance.
What about facilities inspection, maintenance, reporting, contingency plan requirements? Aren't all these things envisioned in the statute to help determine whether a certain point is going to be at compliance? Let me ask you a question. What if we dug a well 100 yards from the point of compliance? Is that legal?
In the statute, what you can do, and the legislature thought of that, it said if it's too difficult at the point of compliance to put the well there and monitor there, go to the paragraphs below, go to paragraph 2. You can move it 100 yards up. They gave ADEQ that option to move it. What they didn't give the option is to just do something completely different, to do it at surface level at one of the 3 discharging facilities at the point of discharge itself. That option is not anywhere in the statute. And so when you look at the statute, the question is, what does determine really mean here? There's no support for the broadest conception of determine. All the support goes in one direction. It is every time determine is mentioned, again, the least common denominator, monitoring at the point of compliance. You can move it if monitoring is going to be impracticable. You can move it if monitoring is going to be too costly.
So I just want, you said it was clear. That's how you started your argument. And so if it's clear, let's look at the language. And so without looking to tools of statutory construction, secondary, the word determine, can you give me one case, one dictionary, any source that defines it as you do, rather than there is a case that says determines is synonymous with fines. It's a Court of Appeals decision from 1983. Doesn't support your argument. So what is your authority to define the word determine as measure or monitor?
So the authority is Drummond itself, which, and then again, I take issue with the concept that this is a secondary method of interpretation. Drummond says this is primary, that to the extent the determination is not, that the dictionary definition of determination is not dispositive on the issue. In a 1983 case, maybe on a different statute or a different context, may not be dispositive on this particular statute. The question here is, how is it used in the statute?
Oh, so you're saying the language isn't clear. Would you say the language is, again, going to the word you used, is the word determine clear on its face?
I think that's a great distinction. I think on its face from the statute, the question of what is the determination, it is not clear from that word. It's clear from the surrounding context. The context gives that meaning. And Judge Morse, it looked like you would like to ask a question.
It seems to me that, and I'm real hesitant to put words in your mouth, so feel free to spit them out after I do so. Isn't your argument that determine means digging a well and testing it that way? I think if we distill it down.
That's somewhat right. There's a bit of nuance there, but the argument is the method of the determination mandated by the statute is something akin to that. Now, it doesn't mean digging a well. I think because it doesn't specifically say
and
monitoring.
I think the counter argument is, okay, so you're saying well or something adjacent.
Something akin. There's room for innovation, I think, in the statute. If in the future, some different method of determining at the point of compliance was invented, or they come across something new that's better than just monitoring, well, they can use that here. It just has to be.
Wouldn't the legislature, if they'd wanted us to say it's got to be a well or actual testing, say well or actual testing? And it seems to me that using the word determine, as you've just, I'm not saying it's a concession, but there's a little bit of ambiguity in what that could mean.
And let me put a finer point on that too. It's not complete absence of testing. It's testing at the point of compliance solely and exclusively.
So why don't we look at what ADEQ is arguing and say, well, we do determine, because we test here and then we also check and make sure that all the other things that they've told us are doing are actually working well, and that allows us to determine at the other points of compliance. Why is that just per se a non-starter for you?
Several different reasons. The statute definitely doesn't say analytically determine. And it is all of the context throughout here, right? Every time determination comes up, it says the default is monitoring in the aquifer itself. That is right in the same paragraph as the point at which compliance must be determined. It's also coming up at the second subparagraph where you talk about how you can move the point of compliance. But if there is any hesitation, just on the statute itself, ADEQ in its response brief brought up another statute, ARS 203 subsection A11. That statute specifically says the director shall require monitoring at an appropriate point of compliance. So there's no ifs, ands, or buts.
Well, so
about
how does that
section.
support? Because isn't that a different section?
How that supports is because the facts here mean there has to be monitoring under A11. So require monitoring at an appropriate point of compliance for any inorganic or organic pollutant listed under a list over there.
Why don't you have that mandatory language in the point of compliance statute? Having it elsewhere, doesn't that sort of lean against your argument under the surplusage canon? Like elsewhere, we're saying it's mandatory. Here, and it's mandatory in that it's monitoring. Here, it's determine
And not mandatory.
and not mandatory. So
Well-
I guess I'm thinking that harms your argument rather than helps it.
No,
Am I wrong?
it helps our argument because you can resolve the whole case under 203A11. They are discharging at non-zero amounts pollutants that are listed on these lists. They are discharging. Now, they will say it is clean water, but all that means is it's below the standards. The water they're discharging still has the presence of some of these pollutants that are carcinogens. And what the legislature did here is not say when there is a discharge that is above the aquifer water quality standards, then you start requiring monitoring. What it said right here is if they have reason to suspect the presence of, at all, the presence of any of those pollutants in the discharge, monitoring at the point of compliance is mandatory. It is required.
So how, as a matter of common sense, is it more effective to monitor, let's say that it's a car wash, okay? And let's say the statute says we will either examine the car for cleanliness as it pulls out of the garage or 9 miles later after it's gone down the highway. How is your argument, as a matter of common sense, more stringent or better for the environment?
So common sense, first, doesn't matter here because ADEQ has to follow what the legislature said they have to do. But even beyond that, here, ADEQ's own hydrogeologist, the people involved in this decision said, here's why we're setting the conceptual point of compliance 9.4 miles downstream, is because that is how long we expect, given the volume of water being discharged from outfall 2, that water will flow and potentially downstream leach pollutants. Now, there's some findings that we can get into the details on those findings, but because of that amount of water flow, that's why they had to set it there. It is not just at that point. That realization of the point of compliance setting takes into account that water, as it's flowing across the surface, can leach pollutants even after when you introduce such a high volume of water. And that's why you have to do it downstream. But even beyond that, we talk about this in our opening brief, there are 3 discharging facilities here. It is not just outfall 2. This is an entire mining operation. So yes, from one discharging facility, they are going to be filtering water and shooting out some small amounts of pollutants, but still some pollutants that could potentially, after the fact, still leach things that are stored in the bedrock down gradient. But there are also 2 other discharging facilities that sit above this aquifer, the Harshaw Creek Aquifer. That's the TSF, that's the UCP, and this is an active mining operation. There are many ways for pollutants at that operation to seep down into the aquifer itself and circumvent what they are monitoring at outfall 2. That's exactly why you have to have a point of compliance in the aquifer itself. The water is not being no one's drinking out of the tap, the spout of the outfall. They're drinking water that is in the aquifer. They're using that for their houses, for their yards, for irrigation.
Let me ask you, let's assume that there is some other way to determine compliance at point of compliance, other than digging a well. Would you accept that, or?
That's fair game.
That's fair game.
I think the statute allows for that, yes.
Okay, and so if we are able to, or whoever it is, able to use those mechanisms to determine compliance, why does the words determine compliance require more, an actual well to be dealt, right? So if you have a toolbox to determine compliance, the hammer is a well. Why can't we look to the other tools and say determine is a verb? Why can't we determine compliance with those other rules?
Because that determination has to happen at a specific place underground in the aquifer. So yeah, they can use other tools, they just have to do it there.
Oh, okay, so it's not, every tool you have is right there.
Yeah, that's what the whole reason for designating a point of compliance. Otherwise, it makes no sense. Why even do this exercise? Why even have this statute that's so in-depth, goes into the location, if we are just going to suppose that we can just do it over here and ignore all of this specific detail?
So what if, because the way that I'm looking at this, or that I understand it, is that if it is physically impossible to receive out of compliance measurements at the point of compliance because of measures that they've taken before that, why is that not a determination, a statutorily compliant determination?
It's not physically impossible. So they are just checking one discharging facility. There is an entire mining operation going on.
Which outflows to two different watersheds.
The water that they are picking out.
Let's talk about the watershed that we're talking about.
But they are mining it at the point of the aquifer, deep underground. They are fracturing bedrock underground. They are pulling water out from nearby areas, that is mine impacted water. This is all happening across an entire property.
Which is being treated.
The water, once it is pulled out above ground, but all of that stuff that's happening underground, they're not testing. So they don't know the quality downstream. At least ADEQ doesn't know the quality downstream, down gradient in the actual aquifer. So no, it is not 100% certain that based on this testing, and regardless, even if it was.
Something you just said gave me pause, and maybe I'm off base, and tell me if I am. But we're only talking about discharge. You're suggesting that because of the mining operation, it may be releasing other things, but that's not what we're here for. We're here to test what they're discharging.
And it's a statute.
The point of compliance statute, first of all, the point of compliance statute, they have to follow it regardless of any of this discussion.
But whatever you're talking about, breaking water releasing stuff in the aquifer, that's not discharge, so that's not an issue here.
The whole point of compliance, there are 3 discharging facilities.
Answer my question.
Yes, I'm trying to.
And it's discharge is what we're here for.
In some sense, what we're here for is this statute, 49.244, which is a separate statute. The statute is meant to say what is going on in the aquifer. How is this mining operation affecting the aquifer itself? The initial permitting.
We're monitoring discharge. We're determining discharge.
Well, the initial permitting talks about, are the facilities best available demonstrated control technology? Do we anticipate that there's not going to be a violation of the aquifer water quality standards? If that's so, then you get the permit. That's the initial determination. But the whole point of compliance idea is go check the water just to make sure, right? It's not just about the discharge itself. And there are 3 discharging facilities. Each facility is a discharging facility on this site. Not just Outfall 2 and WTP2. They all 3 had to be permitted and included within this permit.
So let's say we bring in hydrologists, I don't know who some scientists, and they say this isn't digging a well right here. It's digging a well 100 yards away. But you know what? As a matter of science, and I'll put my name on it as a science, this complies. That is not even, under your reading of the statute, that's illegal.
The legislature told.
Right, that's illegal.
Yes, the legislature.
Scientist looking at the facts and saying, don't worry, this complies. It's my professional opinion. That's illegal.
Yeah, ADEQ, what they have the option to do is move it 100 yards forward, as the scientist said. What they can't do is ignore the statute and violate the law. They have to abide this statute.
So you only have it, real quick. The federal statute, the CFR, doesn't that say you monitor at a particular place?
So, oh, excuse me. I'm sorry. So the federal statute is irrelevant, and I'll point you just to ADEQ's brief itself.
I'm not saying relevant or irrelevant. Does it say you're supposed to monitor at a specific place?
But Arizona's scheme.
Yes or no?
Oh,
Yes
it
or
does.
no?
It does. I think so, but I have to double check. I think that's right.
Okay. If it does, then why are we to intuit or put in words into our statute that the federal government thought to put in, but our legislature didn't?
Arizona's program is not based on the federal program. This is straight from ADEQ's brief. Unlike the AZIPTES program, page 14 of ADEQ's brief, which is a federally approved program tied to the Clean Water Act, the APP program is solely a state program.
I'm just looking at statutory interpretation. Okay, we have words in the English language. Why weren't those words used by the legislature here when they were used by the federal government there? I'm not saying they're the same or they have anything to do with each other.
Well, we could do that exercise ad infinitum. We could look at any state could have the word monitor or not. Did Arizona look at it when it adopted its statutes? And there's no evidence that that is the case.
You earlier pointed us to a place where Arizona did say monitor.
Yes, and we think that mandates, in this particular situation, monitoring at the point of compliance. So both are a resolution for this court.
I'm sorry to take up your time.
No, thank you.
Mr. Thomas.
Good morning, and may it please the court. My name is Paul Phelps. I'm here with the Attorney General's Office representing the Department of Environmental Quality. I'll be splitting time today with counsel for intervener South32, Mr. Chris Thomas. Respectfully, I think the department and I would disagree that Arizona doesn't have many programs regulating water quality. We have quite a few to deal with, including the federal.
Counsel, would you agree that your colleague's suggestion is the most intuitive way to measure compliance?
No, I would not.
Why?
Because really, when you're looking at the effect of a discharge, like you mentioned, you have to use all of the tools in your toolbox, and so you have to look at what's going on in the surrounding aquifers, and you have to take in all the data. In this case, there's data about seeps and springs in the area. Those seeps and springs are groundwater coming up from below, expressing themselves. So you're really looking at the pollutants in the discharge and analyzing from a scientific perspective what impact do you think that's going to have on aquifers in the area.
And that's because the question is not about what is naturally occurring underneath the ground or being released around from what admittedly contains zinc and lead naturally underneath the ground, correct? And what we're talking about, what we're concerned, what ADEQ is concerned with, is what the mining operation is doing. Is that not so?
Right. So we're concerned with the water that South32 is discharging from Outfall 1 after it's been treated in Water Treatment Plant 1.
So the Aquifer Protection Permit program, its intent is to make it such that miners, potential polluters, are not loading additional pollutant into an aquifer. Is that fair?
Well, it's really two things. It's to ensure that aquifers that are meeting standards, that we don't push those aquifers to a place where they're no longer meeting standards, or if you have an aquifer that does have a problem, that you're not making that problem worse.
Right. So, in other words, when someone is doing something that could change an aquifer, whether the state agrees to allow them to do so is dependent upon whether they're able to mitigate to a point where it's not going to be harmful.
Yes, it's based on a scientific determination of how that discharge will affect aquifers in the area. And of course, aquifer monitoring can provide you some data about the effects of a discharge, but so does monitoring the surface discharge. And in some ways, monitoring the surface discharge is actually more effective because really scientists talk about aquifers moving on geological timescales. The evidence in the record below is that the rate of the velocity of flow in the aquifers in this area is less than a foot per day. So if you're asking what is going on in the aquifer at the point of compliance, 9 miles below South32's facility, you are going to have to wait something like 136 years to find out what happens to a drop of water that's discharged from the end of the pipe. It would take 136 years to get down to the point of compliance. So in a lot of ways, if you're monitoring at the discharge and getting an impression of what the surface water is doing, you're getting the best possible data to calculate the effect of the discharge.
What is your best support for your argument that we are doing something, or that ADEQ, you speaking as the royal we, are doing something to determine the impact at these other compliance sites?
I think it's the plain meaning of the word determine. I mean, dictionaries.
Right.
It's
Assuming that determine doesn't just mean dig a well and test. What are you doing to determine?
So I would say that the department is holistically looking at all of the data associated with the facility and with the environmental conditions in the area.
Okay.
So the guiding principle I would say for this court is
And what are some of those holistic things you're doing?
So in this case, the department looked at the influent chemistry, that's the water coming into the treatment plant, at the outfluent, the chemistry of the water going out of the plant. It looked at the treatment technology South32 was using to make sure that the treatment technology was up to the task. And it looked at the environmental conditions in the area. As I mentioned, it looked at the seeps and springs data. It looked at the ADEQ's 2003 TMDL analysis, which is a federal Clean Water Act program that classifies the quality of surface waters. And it looked at data from wells in the area. And it also looked at the characteristics of the creek bed where the water.
And it's also
is.
testing the discharge at that one point.
Yes, at the point of discharge, the water is being sampled, and then.
So your argument is you put all this together, all this analysis and holistic, which I don't know what that means, but we'll use it. And we determine that based on this, we can also be confident that we've determined that the downstream effects are going to be negligible or within the range that you're allowed to.
That's completely right. I mean, you might call it a totality of the circumstances test, but I don't think the department uses that language. It's just looking at all of the data before it to make a reasoned technical judgment.
So two things. Okay, so my first question was just, is that the most intuitive, or isn't it? It's an intuitive way. You would concede that, right? I mean, they're not suggesting some crazy means to test it. They're saying test at the point of compliance. So is that, would you concede that is an intuitive, possibly the most intuitive place to be 100% certain of compliance?
I would say it's intuitive that a measurement, whether it's at the point of compliance or anywhere else along the path of the discharge, either at the point of discharge or somewhere in between, it's intuitive that those things can be part of a determination. And I think, again, the ordinary meaning of the word determine, I mean, a physicist can determine the speed of a falling object without using a stopwatch. You could use a stopwatch, and that would be an intuitive way to calculate the speed of the object, but you wouldn't say for certain that a physicist can't determine the speed of a falling object without a stopwatch.
Because the physicist determines all of the vectors going into what it is, and you can, from there, reason to a determination about what that speed is, correct?
Exactly. If you know the height and you know gravity and air resistance, you can arrive at a pretty accurate estimate of the speed of the falling object.
Well, one thing that's concerning is the department seems to be blending the aquifer protection permit program, and then here's another acronym for you, the PDS, right? And like using one to measure the other. How do you respond to that criticism?
That is not what is happening here. The requirements in the two permits are independent. The department has not put these requirements into this APP permit. And specifically when we're talking about discharge limits and monitoring for those discharge parameters, the two requirements are independent. And in fact, the APP permit contains a number of limits that are not in the AZIPTES permit and a few that are more stringent. So to rattle off a list of them, I believe they are antimony, arsenic, barium, beryllium, chromium, cyanide, fluoride, nickel, selenium, thallium, and nitrates. None of those are in the AZIPTES permit, and the APP permit is stricter on cadmium.
Right, but I guess my point is this, that under Arizona law, they must be kept separate, right? Those two programs?
Well, I would point the court to ARS 49-243, I believe it's K, and one of the factors, I'm actually not confident on K, but in 243, it does allow the department to consider any other state or federal permit that the facility may hold. So the department can consider the AZIPTES permit, again, in the totality of the data it's looking at to understand the impact of a discharge.
But ARS 49255.01G, you familiar with that?
Generally.
Okay, and we're just talking, my point there is keeping these separate,
Yes.
okay? And you're not keeping them separate here. You're using one to measure both. Is that true?
No. So we're not saying that because they have an AZIPTES permit, they don't need to conduct any monitoring under the APP permit. We're not saying just comply with your AZIPTES monitoring requirements and that'll fulfill your duties under the APP program. They both involve surface monitoring, but the monitoring requirements are separate and the two permits are separate. Another point I'd like to get to before I turn it over to Mr. Thomas here is the point, PAR's argument about ARS 49203A11. And I would note for the court that this is the first time, PAR makes this argument for the first time in its reply brief that provision governs this case. And that provision does not govern this case because if you look at 49203A11, it references a list of pollutants that are listed under ARS 49243 subsection I. And if you go look at the list in 243I, all of those are organic pollutants. So PAR is claiming that this applies because the mine discharges lead and arsenic, but the lead and arsenic that the mine is discharging, those are inorganic pollutants. And 203A11 and the list in 243I, 243I only applies to organic carcinogens. And so that's...
But it is only raised in the reply, right?
It is only raised in the reply.
Because I thought I was
don't need to
missing
get
something.
there.
Okay.
And with that, I think I'll turn it over to Mr. Thomas unless the court has any more questions for me.
Thank you, Mr. Phelps. Mr. Thomas.
Thank you. May it please the court, Chris Thomas on behalf of South32 Hermosa, joined today by Todd Gwillem, who's the corporate counsel for the company, and my Perkins Coie colleagues, Diane Johnson and Ben Logbottom. Let me start first by correcting the mistaken impression about what's going on at the operation today. The new water treatment plant number 2 is the one that discharges into Harshaw Creek. We've had a lot of discussion about whether the compliance of the facility with its permit limits needs to be, quote, determined by placement of a monitor well at the point of compliance 9.4 miles away. Mr. Phelps has addressed that issue. What's going on factually, however, is that the company is engaged in exploration of an ore body in the subsurface. 85% of the water that's treated and then discharged from water treatment plant 2 is groundwater, not impacted by mining. It's impacted by the ore body that's naturally there. So what the company is doing actually is making the groundwater cleaner than it otherwise would be if it wasn't pumping it out and treating it before discharging it back. And so it's odd that PARA, which claims to be concerned about the quality of groundwater, would apparently prefer that the naturally occurring metals be left in the ground to migrate down, gradient downstream underground to the point of compliance. Secondly, I thought the car wash analogy was a good one. We know for sure that the quality of the water being discharged.
You can't appeal to his ego like that.
So, but But not only does it, under your analogy, not only would PAR suggest that the cleanliness of the car be evaluated 9 miles away, but also 136 years later. That's just crazy. Secondly, so we know have the APP permit has a variety of means to ensure compliance with the standards.
Counsel, can you talk to substantial evidence argument?
Yes, there is substantial evidence in the record that DEQ did not make a technically invalid judgment in issuing this permit. There are a ton of measures in the APP itself ensuring compliance. We have the monitoring at the point of discharge for 17 metals that occur naturally in the groundwater and that we pull up and treat, including lead and arsenic. That happens quarterly. In addition to that, there is monthly inspection of the integrity of the tailing storage facility, weekly inspection of piezometers in the TSF, which will indicate whether the water level is changing in some fashion that would suggest a leak. We measure weekly or after rainstorms, the freeboard, the clearance from the underground collection pond. We inspect the integrity of the embankment and liner on a monthly basis. We sample quarterly for pH. We sample for retroactivity. In the APP itself, there are 10 pages of description of potential contingencies, things that might go wrong, and then a very prescriptive step-by-step mandate that here's what you do about it.
Okay, so the other tools in the toolbox, in your brief that you talked about.
Yes, those are other tools in the toolbox.
Can you also explain in your argument about the federal law and how that's material here, the use of words in that CFR that aren't used here? I thought it was in your brief. Maybe it wasn't.
Well, I think I probably sowed more confusion than I should have. But basically, this operation is regulated by dozens of permits, including the APP, and a companion permit called a ZIPIS permit, which is a Federal Clean Water Act permit. That regulates discharges to surface water bodies. It's similar to the way that the APP is intended to protect groundwater. And so the same discharge from WTV2 requires both permits to be met. It doesn't turn out to make a difference here, but in many instances, the treatment standards under the ZIPD's surface water program are more stringent than the APP standards. I thought that was a point of interest and provided further reassurance that things wouldn't go bad here. In terms of the issue of whether the APP inadequately imposes its own permit limits, that's belied by all the monitoring requirements and all the other toolbox things you've mentioned. The only thing really that's in the ZIPD's permit that's not in the APP program is the ZIPD's permit requires pH to be monitored weekly rather than quarterly. That provides, let me talk about one other pathway. There didn't seem to be much dispute that at the end of the pipe, this water is clean enough to drink. Drinking water standards are aquifer water quality standards.
So I'm pointing to 40 CFR section 264.95. And
Are you familiar with that?
Yes.
okay, and it says, I think quote, monitoring must be conducted, end quote, at a particular location. So that's federal law, right?
Correct.
Do we have that equivalent in state law in our and could we have, and if it's not in there, why?
We do not have that, Your Honor, and as you pointed out to counsel for PARA, just as a matter of statutory interpretation, the federal government, when it wanted a physical monitor well to be placed at a certain location and monitoring to be conducted at that location, used that terminology. The legislature didn't. And so that statute doesn't govern here, but it is an illustration as a matter of statutory interpretation that words have a meaning. Determined means something different than monitored.
So what of the argument then that the context requires or necessitates that interpretation?
Your Honor, I believe Mr. Phelps has pointed out that Parra's argument there refers to the fact that a different provision of the APP statute does require a monitor well to be placed if you are discharging organic pollutants that also happen to be carcinogens. Those aren't our facts, and so there's nothing in the APP statute anywhere that compels the result that Parra suggests.
And that was 49-203A11.
Correct.
That actually says that it requires monitoring at an appropriate point of compliance for any organic or inorganic pollutant listed in 4923 subsection I.
Correct. And if you go to 49-243I, which is the list to which actual monitoring applies, you will see that it applies only to organic pollutants and not inorganic ones like lead and arsenic, which is the basis for Parra's argument. Let me address the second pathway argument. It appears that Parra concedes that the water treatment plant 2 discharge, which is overwhelmingly the biggest volume here, is clean as it leaves. And so their other speculation below was that, well, your stuff might be clean, but there might be somebody else's contamination in the creek bed that would be leached out by your discharge and travel from the surface into the groundwater below. Two things need to be true for that pathway to take place, however. And the first is that the discharge from WTP2 would need to be acidic. The record is clear that this is not the case. The wastewater discharge is not acidic. The influent, the naturally occurring groundwater pH, is neutral to slightly base, and in addition to that, the treatment plant is required to discharge water with a pH of only between 6.5 to 9. So we won't be discharging any acidic water. It's unlikely even that the groundwater natural pH will require treatment at all. So whether there is anybody else's metal pollution downstream or not doesn't matter. In addition to that, let me mention that there is water quality data suggesting that the creek bed is not now impaired by the conduct of others. I see I'm out of time. I'm happy to answer any questions.
Thomas.
Thank you.
Mr. Ansel, we have a few seconds, so let's put 30 seconds on the clock.
Thank you, Judge.
Hold on 1 second. Let me.
30.
I remember how difficult it was to set these things.
That's right, you can help out.
Give me 1 second. There you go. Go ahead.
Sure. So just touching on the 203A11 issue, this is critical to the case. It is only in our reply because for the first time ever, it was brought up in the answering brief. That cannot possibly be waived. They can't bring up an argument in the answering brief and then foreclose us from responding in this court getting it right.
Before we do that, I just want to ask, do you agree that the water as it's discharged is drinkable?
It is below the aquifer water quality standards.
Okay, so if something that is inherently drinking water is hitting that line and is within pH balances that are not sufficient to cause leakage, how is that not sufficient to assure compliance?
Because this permit program takes into account, and that's the whole point of compliance not being there, the effect of spewing out 6 million gallons every single day and what that is going to cause to a place ridden with mining history in terms of that water leaching additional pollutants down gradient. And on 2 or 3
So what you're saying is that if there's a 1,000-year storm that happens that loosens mining tailings or anything that activity that is there, that's just a natural occurrence. But when South32 does it, then that's not okay. That's your argument.
Yes, when 6 million gallons every
How
day.
would 9 miles downstream monitoring be able to distinguish between a real heavy rainstorm and what they're doing up ahead or further upstream?
Because that is given the volume of water, how long they expect that water to be flowing down gradient. And that's within the testimony. And again, organic, inorganic, 203A11 says both. And so it overrides.
Thank you. Council, thank you for your arguments. We will take this matter under advisement and issue our decision in due course, and court is adjourned.
Recess.
Oh, I'm sorry. Court stands in recess.